2024 CR 011984 State versus Daniel Montoya. Could I have parties announced?
Ashley Jones for the state.
Arlene Gay for the defendant.
And are you Mr. Montoya?
Yes, ma'am.
All right, this is what I'm going to do. I know that previously we had the plea, and then there was some question of maybe he's not competent.
Correct.
So I think it would be best so that the record can be clear. We will just do the entire plea over again as far as me going over his rights with him, because now it's 100% certain that he is competent.
Okay, I think that's fair.
All right. I'm sorry, can I have the file stamp back?
Over.
Yes.
Okay.
And it's just so that we can make sure that the record is clear, okay? And what I can tell you, whatever plea bargain agreement that you all had previously worked out, I know that I was intending to follow it until we stopped in the middle of the plea, okay? All right, court is calling 2024 CR 011984 State versus Daniel Montoya. Could I have parties announced?
Ashley Jones for the state.
Arlene Gay for the defendant.
And are you Mr. Montoya?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Montoya, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
All right. Counsel, do you waive the reading of the indictment?
Yes, we do.
All right. And I do have an application for deferred adjudication, but he is not applying. Is that correct?
That is correct. We are asking the court to sentence him to the 2 years, and I've discussed this with him multiple times, discussed it with him today, and that is what he wants to do.
Oh, right.
Is that true?
Yes, ma'am.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right. You're charged with aggravated assault with a deadly weapon. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
The plea will be to.
All right, let me go over it again. So right now, what I'm going to do is I'm going to tell you what your rights are, and I want to make sure that you know what your rights are. So do you understand that you have a right? Let me go back a little bit. Here you go, counsel. Do you understand that you're charged with aggravated assault with a deadly weapon?
Yes, ma'am.
All right, the range of punishment for that is anywhere from 2 to 20 years in prison. Do you understand?
Yes, ma'am.
And it's up to a $10,000 fine.
Yes, ma'am.
My understanding is that you've reached an agreement with the state for 2 years in the prison. Is that correct?
Yes, ma'am.
I don't have to follow that agreement. Do you understand that? No. Here's the thing. No. I want you to listen, okay? Breathe. All right. I don't have to follow that agreement. So let's say I don't follow that agreement and I say I want to give you 3 years, right? Not saying that's going to happen, but let's use that as an example. If I were to do that, you can withdraw your agreement and say, well, we don't have an agreement because I agreed for 2. You understand?
Oh, yes, ma'am.
All right. So that's what I mean. So I don't have to follow your agreement. If I don't follow your agreement and I try to give you more than 2 years,
I'm gonna say no.
you're going to say no, right? All right. So you understand that.
Yes, ma'am.
All right. You have a right to a jury trial. So 12 people would sit on the jury. The state would have to present their evidence. They would call witnesses and your attorney would get a chance to question them. All right. You also, the state could turn to you and say, hey, now we're going to call Mr. Montoya to the witness stand. They wouldn't be allowed to do that because you have a right to remain silent. Do you understand?
Yes, ma'am.
All right. If you enter into this plea bargain agreement, you're giving up those rights. So what that means is the state is not going to call any witnesses. You understand?
Yes, ma'am.
And that means that if somebody wants to call you to testify to something, they can, because you're saying you're not going to remain silent if somebody wants to ask you questions. Do you understand?
Yes, ma'am.
Now, by entering this plea, you're agreeing to all of that. Do you understand?
Yes, ma'am.
And do you agree to all of that?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
And did you have him evaluated for competency?
Yes, I did.
And the results?
He was found competent.
All right, Mr. Montoya, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than this plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's a $500 fine. There's an affirmative finding of deadly weapon, and there's an affirmative finding of family violence, and there's no application for deferred adjudication. Did you understand that?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
And did you understand you're not allowed to be designated as primary custodial parent? Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes,
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? This paragraph.
Yes, ma'am.
Did you understand it and sign it in both places?
Yes.
All right, so by signing that, what's happening is you're giving up your right to appeal. Your
Okay.
right to say, you know what? I don't like that deal. Now that I've had a chance to think about it, I changed my mind. You're giving up that right. You understand?
Oh, yes, ma'am.
Now, there are certain things that you can still say you want to appeal on. For example, if your attorney has filed some sort of pretrial motions, I've heard it, I've ruled on it, you can still appeal as to that. Do you understand?
Yes, ma'am.
Counsel, have there been any such motions?
no, there has not.
All right, then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State would offer State's Exhibit 1 and all attachments.
No objection.
And state, have you spoken to the complainant?
Yes, Your Honor.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver? This packet with your attorney? It has the police reports and everything in it.
Yes, ma'am. She did.
All right, did you understand it and sign it?
I think I did.
All right, so let me show you. Is that your signature?
Yes, ma'am.
Okay,
Your Honor, if the state may just make a comment
sure.
on the previous plea that we did, the state waived count 2. I forgot to go through that again.
All right, okay, thank you.
Yes, Judge.
Any objections to
No,
count two?
No objection.
All right, so again, you have a right to a jury trial. Right for you or your attorney to question any witnesses the state would call, and the right to remain silent. By entering into this plea, the state is going to give me evidence on this case, but that evidence is going to come from police reports and witnesses' statements. So nobody's going to come in and testify. I'm just going to read this document and see if there's enough evidence in here to find you guilty beyond a reasonable doubt. Do you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're just asking the court to follow the plea bargain and also that time and money run concurrent.
All right, so with regards to the parties involved, they appear to be all related.
Yes, a brother and a sister.
So there may be a need for no contact. What's going on with that?
That was the problem with this case initially on bond, is that he lived with his grandmother a bit. His
Mhm.
brother and sister lived, I think they were allowing 1,000 feet.
Mhm.
And they live within that 1,000 feet. But I believe from just discussions that everybody's kind of made up, Your Honor. He will go back and live with his grandmother. My client is mentally ill. And so that's who kind of takes care of him, and they take care of each other.
All right.
But, and the sister who was involved in the brother, they've spoken to the district attorney's office. So
All right, and state with regards to the no contact, are you requesting no contacts or no?
The state is requesting a no contact, Your Honor. Understanding defense counsel's position, but this was a case where a deadly weapon was involved, so I will proffer to the court that at least you'll give me one moment. The complainant with the first name of John has informed us that he wants a no harmful or injurious contact order. And just a moment. I don't have what the complainant Ramona would want, but she did recant.
She's been very vocal, to say the least, in favor of trying to assist her brother as opposed to assisting the state.
That is correct, Your Honor.
And they don't have parents, so grandma is the person in their life. And I think no harmful or injurious would be appropriate, because without him being able to go live at grandma's house, he doesn't have a place. And this case kind of proved it when we were trying to get him out on bond, and he had no place to go. And they put him in Lifetime, and he did do the program at Lifetime Recovery. We assisted him with his mental health and also assisted him with alcohol addiction. So he did complete the Lifetime Recovery program during the pendency of this case.
Okay. All right, this is what the court is going to do. The court is going to find you guilty. There's an affirmative finding of family violence, an affirmative